to turn the recording on.
I see it.
Yeah.
I just got my prompt.
Up and show presenter view, and there we are. All right, so folks, we're going to get started in just a minute or so here. We're just about on the top of the hour. So we'll give it probably like another 30 seconds or so, and then we'll get rocking and rolling this evening. All right, so I'm going to get started just because that makes it easier for us to try to keep everything on time and keep us moving along. So this is Thirsty for Knowledge Thursdays. It's a weekly webinar series that's brought to you by the Aries Foundation for Financial Education. I just want to make sure that everybody is on, let's call it the right flight this evening. And so tonight's presentation, we are doing estate planning, specifically looking at and talking about beneficiary designations and why that's important, not to every family, but just to especially those we'll touch on a little bit at the end, consideration for those with a child who has special needs. So a little sort of pre-flight checklist here before we take off. All your microphones are muted. The cameras can be on or off. It doesn't really matter for us as far as that's concerned. There is a chat box. So there are, if you have questions, feel free to put them in the chat box. I will tell you my co-pilot, who I'll talk about in a second, who is normally on the flight with me to keep me on pace and be reviewing the chat box. We gave him the week off. So Craig is off in the hinterlands enjoying himself and spending time with his family. So he's not here to monitor the chat box. But if you do have questions, we'll try to catch them. If we don't, at the end, there is time for Q&A. So we'll try to bring it up at that point. Speaking of which, your presenters for this evening, your pilots for tonight's flight. I am Tom Alessi. I am the president of the Aries Foundation for Financial Education. In my other life, I am a financial advisor, actually an investment advisor. I've been doing that for more than 20, it's over 21 years now. What that means is that I act and have to act as a fiduciary when dealing with my clients and dealing with any investments, guidance, or advice that I am giving. My co-pilot, who, as I said, is absent this evening and not sitting in the other chair to helping me with this flight, Craig has been in the business for about 16 years. He's a financial service representative, and Craig's side of our sort of tandem focuses more on planning and protection strategies. He's more of the planner. I'm more of the investment strategist, and that's just sort of the ways to think of us. As I mentioned, this is brought to you by the Aries Foundation for Financial Education. You can visit us at ariesfoundation.org. Our mission, the reason we founded it and launched Aries, was to really try to help everyone have a better relationship with their money. Our belief is that financial wellness is a contact sport, and we mean that literally. I'm in my Patriots jersey here that, they're playing tonight. It's Thursday. They're Thursday night football, but we mean it as a contact sport. You can see us, we're in the jersey and the website. And if you go visit it, you'll see some of the presentations that we do. But we believe that there needs to be guidance. There needs to be hand holding. There needs to be one-on-one with anyone, because there's hundreds of, tools and calculators and websites out there to help you. But if you don't have that one-on-one, you're not getting the participation. And that's really what we believe in and why we launched the Aries Foundation, to help with that. A couple of disclosures before we get started. The presentation is meant for purely educational purposes. We share this on the website. We share it on our YouTube channel. If you want to use it or share it, we feel free, go ahead. We just ask that you use it for educational purposes only. The Aries Foundation for Financial Education is a nonprofit. We are not affiliated with any securities related broker-dealer, and we are not an investment advisor representative. We're not a registered investment advisor. I said that backwards. Craig and I strongly suggest to everybody that if you ever have any questions, regarding tax, legal, or financial situations, that you seek out the help of a professional to get those questions answered. Well, that was a lot for me to go through right there. So it brings me to the best part of this. We do call it Thirsty for Knowledge Thursdays, what we affectionately refer to as Think with a Drink. And we say that because for us, we want you to be engaged, and we can't think of a better way to have you engaged than be to relaxed, enjoying yourself. And in our case, that's pouring yourself a cold one. What I am drinking this evening is one of my happy places on the planet, which is Jack's Abbey. They released this fall lager called Shipping Out of Boston, which is a takeoff on the Shipping Up to Boston by the Dropkick Murphys. For those of you who cannot imbibe or who choose not to, hopefully you can pour yourself something that you're enjoying. And the whole idea is, again, be relaxed and have an interesting time that you'll get some education from this. Skål. See, that's the other reason I have Craig here, because then Craig can tell me what he's drinking, and that sort of gives the opportunity for me to actually take a sip right there. All right, so the agenda for this evening, I'm going to introduce our special guest presenter in just a second, but we're going to cover estate planning, the basics, some recommended documents, some of the picking Amanda's brain on that. We'll touch on assets that pass by beneficiary, assets that don't pass by a beneficiary, and why that matters in this whole conversation, the different types of designations that you can choose as a beneficiary, and why doing a review is very important. And then, like I said, we'll also touch on considerations for a family with a child that has special needs. Some of this, as we go along, I will be dropping in some situations that have occurred, some situations we've run into with clients, some of them that have just been heartbreaking, and some, in the case of my own family, was kind of funny because of my situation and who I am. But with that, I'm going to introduce Amanda. Amanda, I'm going to bring you on. Go ahead, if you can, just spend a couple of minutes, just let folks know who you are, what you do, a little bit about your background. See, now I can take a drink.
Thanks, Tom. Thanks for inviting me tonight. I'm happy to be able to participate. So my name is Amanda Mulhall. I'm an estate planning attorney. I have a practice in Natick, Massachusetts. I focus my practice on families who have minor children, because as we'll talk about a little bit later, families who have minors, if something ever happened to the parents, it gets a little bit more complicated when your kids are under the age of 18 than if they are adults and can take care of themselves and take care of their own finances. I also do probate administration and estate administration as well. So everything that I do for estate planning is really based on the experience of going through probate and seeing how maybe missteps or mistakes actually play out in the probate process. So the beneficiary designations that we're going to be talking about tonight are actually really relevant to this conversation, because even a small error can result in something pretty big potentially.
Yes, absolutely. And yeah, and we're very fortunate and appreciate Amanda taking the time to come with us and to go through this. And I will tell you, this topic I've been waiting for a while to do, because it is very, very near and dear to my heart. Because like I said, we have had a lot of situations over the years with different clients where there's been problems and things that have come up. But as we go along, and like I said, one of the ones is, as we talk about it with some of these, I'll get into it, what happened with my situation with my family, specifically with my dad, and how this all relates to it. But I want to start with the basics, right? So really for Amanda, for the general question, because Craig would chime in on this as well, is we sit down with people all the time and we always ask them, do you have a will? And so the question is really, why does anybody need a will?
Yeah, so when we talk about an estate plan, sometimes that seems like a really big word, and a lot of people feel like they don't have an estate. But an estate is just your stuff, right? It's your bank accounts, it's the tangibles in the place that you live, it's your real estate, potentially life insurance, retirement accounts. All those things are part of your estate. So try not to be intimidated by that word. There are some foundational documents that you want to have in place. Everybody should have in place once they're over the age of 18. the main one that people think of is the will. So really what a will is the document that can direct the disposition of your assets. So it's essentially you saying, when you pass away, who you want to receive all the assets that you leave behind.
Right.
Um,
And so, Amanda, just to jump in with that, so I'm married. Doesn't my wife automatically get my stuff?
So that can be the case. So if someone doesn't have a will, Massachusetts by statute sort of tells us what happens to your belongings.
Okay.
But that's not for every type of asset, which is where the beneficiary designations come into play. Because really we're only talking about probate assets. So a type of asset that I would own individually, for example, a bank account. If I was the only person who owned that bank account, it doesn't pass by operation of law. Like, for example, if Tom and I owned a joint bank account and I passed away, Tom would then become the 100% owner of that bank account. So
Right.
really a will is going to dictate what happens to all of my individual assets that aren't beneficiary designated, that don't pass by operation of law.
Okay. And so then sliding with that and sort of picking up from there, right? Those, the other documents. So a will is important, but then, I've heard and we had this conversation because, my kids are now 18 and 22. That's, the last time we looked at the will was probably 20 years ago, that realized I don't have a healthcare proxy or a power of attorney or any of that stuff that goes along my understanding that should be there. And so one of the questions that comes up a lot is sort of the healthcare proxy, living will, like what's the difference between those?
So the documents that you were just talking about, healthcare proxy, power of attorney, living will, those are for if you have not passed away, you are still living, but you are incapacitated and unable to make your own decisions for yourself. You're designating in these documents who can do that for you. So in a healthcare proxy, for example, you're listing the people who you want to give the power to communicate with medical professionals and consent to perhaps a procedure on your behalf or consent to the administration of medication if you weren't able to do so on your own. So there are some documents that go in tandem with the healthcare proxy. One of them is a living will. So what that does is it really outlines, actually in Massachusetts, is an important note. You're not permitted to have a legally binding living will in Massachusetts. So it really serves more like a memorandum to your healthcare agents about what you would want them to do if you are in a terminal condition or persistent vegetative state. There is no reasonable prospect that you are going to regain any meaningful life, so that your healthcare agent isn't in a position of making that decision for you and then feeling bad about it or not really knowing what you actually wanted. So it's
So is
really,
that the do not resuscitate, the DNR situation? Is that
it's a little different than a DNR. I get that question with almost every client. Um, it's particularly important because I tend to work with younger people who wouldn't necessarily want a DNR because we want doctors and medical professionals to do everything in their power to bring you back. So this is the living will is really if there was no prospect that they were going to be able to do that, right? They've exhausted all of their options. The only way you're being kept alive is by artificial means.
okay? And so now the other one that I mentioned and what I have heard and talk to clients about all the time is power of attorney,
Yeah.
right? And so does it really make sense? Like, do I need a power of attorney?
So a power of attorney covers any legal or financial matters that the client has. So a lot like the healthcare proxy, in this document, you'll list the person or people who you want to give these powers to, and you can think of it a little bit like day-to-day operations. Like these people can pick up your mail at the post office for you, or talk to a financial institution on your behalf. Um, they can make legal decisions for you. So, say the reason you were incapacitated is that you were in a car accident and somebody was suing you above and beyond your car insurance. Your power of attorney could use that document to actually step in and respond to that lawsuit on your behalf in whatever way was appropriate at the time.
Now, so I've heard durable along with power of attorney. What can you explain durable to me? What does that mean?
Right. So the term durable means that this power will continue on even if the client or the principal has lost their capacity, right? So if we're doing a power of attorney, sometimes people remember if maybe they purchased a house or they were selling a house and they gave their attorney a limited power of attorney for just that one transaction, right? Maybe the client couldn't show up. They gave their attorney that power so the attorney could sign a couple of papers for them and the client wouldn't have to come to the transaction. A durable power of attorney is different than that. It's something that if I was the client, I could create now. And I'm telling the world by making this durable that even if I was alive but incapacitated, my agents who I've appointed, they still have full access, full power to act on my behalf.
Okay, I get it. All right. So let's slide that over now and talk about those assets that pass by beneficiary designation. And this is one of the ones like the story that I, where I was talking about have happened and dealt with. So I had a client who, he unfortunately he got diagnosed with cancer. He survived, but it shook him, like really shook him to the point where he was concerned about his wife and his child. And he's like, I want to make sure that somebody knows where everything is. Now, the guy he chose was me. So it was, Tom, you're the guy. I'm worried. I want to make sure that if something happens to me, that, you know where everything is. And I'm like, that's fine. I'm, great. Okay. So we spent hours going through all his stuff, making sure everything was lined up. Great. He unfortunately gets diagnosed with a second type of cancer and passes away very quickly. Now I'm thinking, okay, fine. I know where everything is. I'm handling it with the wife. And then she comes back and says, oh, you know what? I just found this thing from this old bank IRA that he had that we didn't know about, that he never brought up. And unfortunately, his wife nor his child was the beneficiary on that IRA, that it had to pass through someone else because he forgot about it. And he didn't have it anywhere in his records. And so it's one of those where I always mention to people about going back and doing reviews and looking at accounts and trying to find things, because you just never know when this is going to happen. And like Amanda was saying in the beginning, little steps and little things can cause big problems. But a lot of these are, situations that say, okay, each of these life insurance IRAs, annuities, bonds, etc., passed by beneficiaries. But my question is, but what if I dictate something differently in my will? Doesn't the will override this, or is it the other way around?
So it's actually the other way around. So any beneficiary designations in a life insurance policy or retirement account, that actually supersedes any of the provisions of a will. So beneficiary designated assets are actually non-probate assets so long as they're actually filled out correctly. There's a big caveat to that. But if I wanted to leave everything to my spouse, for example, but then in my life insurance, I had designated my parents, right, as the beneficiaries of my life insurance before I got married.
Right.
And then I did my estate plan. I never revisited the beneficiaries on my life insurance. When I pass away, my parents are going to get the life insurance. It doesn't matter what's in my will or any of my other estate planning documents. The custodians of these types of assets, they follow what's on the beneficiary designation.
Right. So the will has no cause in that whatsoever. Now, let me ask you with some of these, because we've run into it and the situation. So what if I don't name somebody? Right.
So,
what if,
right. If there is no named beneficiary, or say you name somebody who's since predeceased, right, and you didn't designate a backup, it would pay out to the individual's estate.
Right.
So the estate is actually, when we talk about an estate, and I used the word earlier about all of your stuff, right, all the things that you own individually, that asset now becomes part of the estate. And that is actually what goes through the probate court. So if you have no estate plan, or even if you have done a will, all of these assets have to, before they go directly to the beneficiaries of the estate, have to go through this court oversight process called probate, which I think we're going to talk a little bit more about later. But the proceeds of any of those beneficiary designated assets that had a blank beneficiary or a failed beneficiary are now part of the estate. And then they would actually pass pursuant to the person's will or pursuant to the statutory scheme.
Right. And Craig and I are literally in the throes of going through this with a situation where the client who died last year, his named beneficiary had predeceased him by a couple of years, and he never changed it. So went to the inherited IRA in the estate, right? Mm-hmm. However, the custodian at that time said, all you can do is distribute the asset. Now, it was a fairly large estate. I mean, we're talking an IRA of, $500,000, where when you take the money out as the estate, you get hit with the max tax right out of the gate. There is no graduated tax on that. Plus the state tax, the state that was involved, you were talking about 45 to 47% of the money going away. And we were able to step in and say, no, you don't have to do that. You can actually, there are rules in place that you can, take the money out in a distributed fashion. And we actually have a custodian that we can actually move it to where, like you said, then becomes the beneficiary of the estate and now is being drawn out based on that beneficiary's tax rate, not the estate on a graduated basis. But even more so, this is 2020. This is COVID. They didn't even have to take the RMD this year because it wasn't required. So there was no tax. So this saved them, I don't even want to go into the amounts of money that was there that was going to happen, but it all comes back to that same conversation, being aware of who the beneficiary is, and we'll talk about reviewing them in a little bit, but it is I can't stress the amount of times we've talked to people, and like you said, that happens a lot when you get those first jobs, right? You're not married. Who did you name as your beneficiary? Mom or dad, usually, or a brother or a sister.
Or a lot of times, people will change jobs, right? And you sign up for all of your benefits. They give you the paperwork. You're not paying attention to that because you're learning the mechanics of your new job, and you think, oh, I need to fill this out and send it back to HR, and there it sits in the drawer, and it never happens. And I see that all the time. And, luckily with the people that I'm working with, part of what we do is to review all of these things like you do, Tom, to make sure that these mistakes don't happen. But it's surprising how often people will kind of think back and say, I don't think I ever did that, and then right. They're reaching out to HR and realizing that it's a very small thing to do, to just fill out that beneficiary form, put someone's name on there who you want to receive that asset, or any variety of beneficiaries that you could name, which we're going to talk about too. But to just do that, which takes 5 minutes, could save, honestly, thousands and thousands of dollars.
Or in the situation like I described before with the other client, where that was an asset he wanted to pass to her or to his son in that case, and it just couldn't be done because he never changed the beneficiary on that one account. It does happen. So I'm going to slide over to, because you mentioned probate a couple of times, and we'll go into that in a second, but I do want to tell the story because this one is more, it's like, I laugh and I joke about it because, so this is my dad, right? So I'm the guy, right? I'm the financial advisor. So, I know where all my dad's stuff is, but it's even more to that. I'm not only just the guy, I am the guy because I'm handling the estate for them, right? I'm the guy who's going to distribute everything and go through all of it. And so I know where everything is. Now, my mom passes away in 2011, and she didn't really have too many things in her name. My dad passed away 6 weeks later. So it was 2011, he passes. I'm going through everything. And wouldn't you know it, there's 2 small brokerage accounts that are just in his name that he never mentioned, never brought up, never said anything about. And I'm left with, how do I deal with this? Because it's not, probate has a certain level, and I'm going to ask you that in a second to go sort of through it. But it literally came to the point that the amount it was going to cost to do the trade, to try to make the transaction and close the account, was going to take away almost all of the assets that were in the account to begin with, because we didn't have somebody else on there. So there was this whole process to have to go through for it. And so I just said, forget it. Now I bring it up because literally, and not to be plugging findmassmoney.com, but if you ever see those ads, I suggest you go in. I do it every now and then because I do it for clients when I go to see people, and I do it for people that I work with. If Craig was on the line, he'll tell you I just found money for Craig on findmassmoney.com when I was going through it. But my dad showed up on the list because the little tiny brokerage accounts had been done to the point where now there were assets sitting in there. And so it's one of those things, and we'll go through it now with those assets that don't have beneficiaries. And so you've mentioned it a couple of times. Can you walk me through exactly what is probate?
So probate is a court oversight process, and the purpose of it is to make sure that the right people get the assets, right? That's really the whole point behind it. How it works is that the court will appoint someone called a personal representative. This is someone who you can appoint in your will. So you can choose that you want it to be your brother who is great with paperwork and finances, and it doesn't fall to your sister who would rather do anything else except fill out paperwork, right? So it's important to name the right person in that role.
I have a couple of sisters like that, but that's okay.
Everyone does. So that personal representative is really responsible for overseeing this process on behalf of the estate. So what they do is they tell the court all of the assets that the decedent owned when they passed away. And this is the individual assets. So like it says on the slide, this would be real estate, bank accounts, brokerage accounts, tangible personal property, things of that nature. Once they're reported to the court, we would submit a will if the decedent had a will to show the court who the decedent wanted to receive those assets. They did not have a will, the personal representative would have to identify the heirs at law of the decedent. And those are the people who are entitled by statute to get those assets.
So that way, because that brings up a point as you're saying that's one of the things that sort of, rambles around in the back of my brain. That one of the things with probate is becomes public record, right?
Yeah,
that's one of the issues with this, is that now all my stuff has to be out in the open. Somebody's gonna know what's going on.
Yeah, absolutely. And the reason for that is because the personal representative also has to put the decedent's creditors on notice. So if the decedent had any outstanding debts, those creditors would have to be notified so that they had an opportunity to come forward and recover any of the debt that they were owed. So because of that, the process is totally public. So that means you can actually go down to the probate court in whatever county you live, or any county, and request a probate file and get it and see, not only the name, the age, and the address of the decedent, but also what assets they owned and how much all those assets were worth and who is getting those assets and when. And that can be very problematic, not only from just a discomfort standpoint, because it's a lot of very personal information, but also if we're talking about people who had young children, or we're talking about somebody who had a disabled person or someone with special needs as a beneficiary. These are vulnerable people who could potentially be targeted by nefarious parties, right? You can imagine someone out there finding out that, a 19-year-old is going to be inheriting their parents' estate. I think there's a lot of potential for targeting a young person in that context. And there's a lot of other, points about probate that are pretty painful for people. One of them being it takes at least a year. So from the time the person has passed away, that probate file cannot be closed up until a year has passed, because that's the creditor period. That's how long Massachusetts gives credit.
I was going to say, is that have anything to do with COVID? I mean, or it's just, is
no,
COVID?
That's always how it goes. So even if there was, nothing to fight about and everything was straightforward, it's still going to take at least a year. And of course, there's a lot of expense that goes into probate. like you said, Tom, it's also public, and it's also problematic, like I said, when there are minors or incapacitated people as beneficiaries who are not able to manage assets on their own, just from a legal standpoint, right? Because they're, being a minor
Right.
is technically an incapacity under the law.
So what steps can I take to avoid, because that's one of the things I try to do with clients is talk to them about, especially if somebody's just passed, right? So somebody just passed, now you sort of, like there was joint bank accounts, but now there's back to single person on a bank account, right? What are the steps somebody can do to sort of avoid or make sure that the assets don't then fall under probate?
So one very commonly used technique is implementing what's called a revocable trust. So there's many kinds of trusts out there that serve different purposes. And a lot like the word estate, where people think I don't have an estate, a lot of people think they really don't need a trust, right? Because they're not like
Right.
Bill Gates or something. But this is actually the kind I'm talking about right now. The revocable trust is actually a very flexible document that
So
allows.
I'm gonna segue to the next screen for you in
Yeah.
terms of that, because that gets into the different types of beneficiaries.
Right. So a
Right.
trust, yeah, can be a beneficiary of any of these beneficiary designated assets too, which is actually great. So by creating a revocable trust, the client continues to maintain full control and use of all of their assets during their lifetime. So really what it does is it helps to solve some problems after the client passes away. So the theory and the sort of technique of the trust is that the client wants to retitle all of those individual assets that they own, like real estate, bank accounts, brokerage accounts, into the name of this revocable trust. So, like I said, they still have full control because they'll be acting as trustee, who are the people who actually manage the assets in the trust. But when they pass away and the probate courts is their personal representative, okay, when Amanda Mulhall died, what assets did she own in her name so we could make sure they're going to the right place? There's actually no assets in my individual name because I had moved them and retitled them into the name of this revocable trust that I created during my lifetime. So, because of that, there's actually nothing to go through the probate process. And the trust continues on after I pass away. And part of what I have done when I set up this trust was name beneficiaries of the trust. So if I had kids, for example, and I wanted my assets to go to my kids who are 10 years old, the trust will continue on to hold those assets to be managed on behalf of those children. So we're avoiding probate. So none of this information about what assets I owned or who they're going to, that doesn't become part of the public record. It just doesn't go through probate. We're skipping that year-long process. We're saving all of the money that would go to pay a probate attorney like me, or filing fees or whatever else is going on with accomplishing the probate process. So it not only makes it a lot easier just from an emotional standpoint for the family to not have to go through this long process, it helps to preserve assets too.
Right. And it's also then trying to figure out or remember, like I said and talked about, where all those assets are. Because that's the other thing that's come up with a lot of times, which is trying to go through the documents and old files and find old accounts and figure out what's where and who's got what type of thing. And you wind up in that situation of like, who knows where, 3-6 months later, we're getting a notice on something, right? So, a lot of times that's why we'll tell individuals, like, keep a bank account open with the individual's name on it, because you just never know when a dividend or some kickback from, hey, you canceled the health insurance comes back in their name and you can't do anything with it if you closed out the account. Right. So you mentioned terms, and I'm just going to, I'm throwing you in not under the bus with this, but just in front of it in terms of revocable. And now the other side of that is irrevocable. If you could just real quick with the difference and what they really mean in terms of the terminology.
Yeah. So an irrevocable trust serves all, different purposes from a revocable trust, because ultimately what happens is when someone sets up an irrevocable trust and they retitle their assets into the name of that trust, they're really giving up full control over those assets in an irrevocable trust. There might be different reasons that the individual might want to do that. One might be asset protection. One might be tax reduction. There's a whole a bunch of reasons why someone might want to do that. But ultimately, the client is giving up control over those assets for the rest of their life. So it's basically gifting it away, and not having an expectation of ever being able to access or use the principal again. This is oftentimes not a technique that's very appealing to a lot of people because, myself included, I would love to use my own assets during my lifetime.
Yeah, I want my stuff, right? It's my stuff. I want to keep my stuff.
Exactly. So sometimes people come in with the notion because they've heard on the radio or TV or something, protect your house from the nursing home, put it in an irrevocable trust, but they don't go on to actually talk about what that means and the consequences of that.
And so let's talk about that, because that gets into the whole beneficiary designation thing, right? Like, so I'm designating a person or I'm designating a trust. Like, how does that differ? Why is it different? What does it matter if a trust has it or a person is getting it?
So if we were to take, for example, those 10-year-olds that I want to leave my life insurance to, right? Say my spouse has passed away or I'm a single parent. I want my life insurance to pass to my 10-year-olds. Well, if I'm leaving, $1 million to two 10-year-olds, I can't begin to imagine what they're going to spend it on, right? But in all seriousness,
Skittles.
Yeah, they're not able to legally do that. So if I really want them to be able to have use of the assets while understanding that they're not in a position to control them, naming a trust is a great way of making sure that those assets land in a place that are eventually going to be sort of funneled down to the kids, right? Because I will name the kids as the beneficiaries of the trust. And there will be a third party called a trustee. I mentioned earlier, those are the people who manage the assets in the trust. They'll be able to make distributions on behalf of the kids during their lifetimes. And then I can also decide when and how I want my beneficiaries to ultimately receive the assets. The trust doesn't have to go on forever, right? So I could say, when my 10-year-olds reach the age of 25, my trustees have the ability to distribute the assets directly to them. So by that point, they're adults. Hopefully they will have learned a little bit about financial management, and I trust them at that point to take the assets and essentially manage them on their own and do whatever they want. So the assets will pass to them from the trust. If all the assets are distributed from the trust at that point, it'll really just dissolve at that point.
Right. And just to sort of segue, because you can see the boxes on the screen there that talk about it. The one that we haven't mentioned, and we did the webinar last week was all on charitable gifting, right? So I do want to just, one thing with this is the ability to name a cause or a charity as a beneficiary is certainly something that is available, and you can do with any of those assets that pass by beneficiary, right? As well as in your will.
Absolutely. So what a lot of people do is they say, I want to name my spouse first as my primary beneficiary. I want to name my child second. And if they're not available for some reason, if something happened to all of us, where I want everything to go is to a charity. And you can do that. You can name multiple beneficiaries, because we're always, and this is true for all the estate planning pieces too, we're planning for all possible contingencies. So it's possible to name a charity as a backup. You could also name them as the primary as well.
Right, as I was going to say, because that's one of the things. So with those assets, and we didn't really talk too much about it, but just to quickly go on it, because I think that makes a lot of sense when you're talking about those assets that pass by beneficiary, that you have a primary and you name a backup, or what is known as a contingent beneficiary, right? So a secondary, should the primary beneficiary predecease you, there's a backup in place, whether that's minor children, your kids, or, we do recommend a lot to name a charity or a cause, like you said. Hey, look, it's something that's important to me or near and dear to me as far as going through that, and name that as the contingent so that somebody's getting it and it's not going through that whole estate deal that causes major concerns and problems.
Right. And a lot of times you can name more than one beneficiary at once. So if you are naming children, for example, and you want them to receive equal shares of whatever asset we're talking about, you can, if there's two children, you can name each of them as a 50% beneficiary on those assets too.
So long
So
as
it's
they're
not
round
all
numbers, there's no halves. You can't do decimals, there's no halves. Everything's gonna be a round number. So one kid if it's 3 kids, one kid gets 34, just so we're
right.
clear on that. There's no halves. Yeah, it's like that thing with the one flew over the cuckoo's nest when he breaks the cigarette and tried to bet 5 cents. And he said, no, that's not worth anything. All right, so let's go to doing the review, right? So, we've talked about the reasons and why this is important, but is there a particular time, like you say to individuals, like, hey, now's the time, or should people be designating, like, as things change in their life, they get married, they have a child, whatever it may be, that those are the time periods to go back and review this stuff?
Yeah, I mean, if you're not doing a periodic review, sort of intentionally, there are absolutely milestones that you want to check in and make sure everything's updated right. Definitely, if your marital status is changing, you're getting married, you're getting divorced, that's a big one. If you're having children, that's another big one.
So
If
wait, because you just mentioned the D word. So the time out there with the D word in terms of going through that. Let's talk about that for just a real quick second with that. So divorce. So if I've named my spouse as my beneficiary and we divorce, is she still my beneficiary, or is that changed? Do I have to change it? How does that work?
So this is true of estate plans in Massachusetts, life insurance. When you get divorced from a spouse, that spouse is treated under the law as if they had predeceased you. So what that would mean in a will or a life insurance beneficiary designation, for example, is that we would pretend that your spouse was already dead. And
Does
we
that
would
work in
basically,
IRAs too?
I believe so.
Okay.
I think that's true. We can
So
double
then
check.
that's definitely something that needs to be addressed because that creates that whole issue. So you're telling me that if it was divorced and I didn't name my kids as backup, that it would go to my estate.
Right.
Yeah.
Absolutely. So we want to be sure then that we are prepared for that, because what sometimes people will do if they have young kids is create a very basic estate plan. They, might not be emotionally or financially ready to implement a revocable trust, and they realize the odds of them passing away is very slim. But sometimes what happens is they might have life events, like they get divorced. I'm actually dealing with this in a probate matter right now, where a woman was divorced. She created a will with her ex-spouse when her child was born. Fast forward about 12 years, this individual unfortunately died of cancer, leaving a young child. Well, now they didn't really prepare adequately for the assets to go to the child. Yes, we want the child to be the recipient of all these assets, but they didn't necessarily structure it in a way that is easy for the now recipient of the assets and her family.
Right.
Um, it gets a lot more complicated through the probate process when we have minor children inheriting assets. So, you know, doing your estate plan is a great time to review your beneficiary designations to make sure they're passing the right way. Um, yeah, those are really good times to do that.
Right. And that segues, because what you were just talking about segues into the last part, which is, and we spend a lot of time, Craig and I, doing these presentations in the special needs community, talking about the differences and what you can do, what you can't do, but specifically about the conversation of talking to other family members about those, let's call it good intentions, bad consequences, where, Nana, grandpa left money to the child who had special needs without realizing that that's now going to disqualify that individual from receiving any benefits. And so, the question is, with going through that is, besides, is there any way to do it besides the special needs trust? Is there any, going around that?
I usually recommend a special needs trust really for anyone with needs that might qualify for government assistance, even if they remain unfunded until the grantor passes away. It might be like a child who has special needs or even a young adult. And they may have, their parents may have created a special needs trust for them that's just sort of sitting there empty, but is going to catch all of the assets that are being left to the individual with a disability. Because it's good to have there just in case, right? And sometimes parents with children are not really sure whether they're going to grow up and actually need assistance or not. But it's just good to have that safety net there to make sure that, like you were saying earlier, there aren't unintended consequences by wanting to provide for somebody who needs, government benefits potentially.
Right. And so, and part of that with the conversation, and we have gone through, not only doing this on the higher level, grander scale, but, drilling down into the differences between, first party and third party and pool trusts and all of that is going through it, but it really comes down to that, because not only is this having the conversation with Nana and Grandpa and uncles and siblings and other folks, but goes back to the same conversation where you may have put the child down as the contingent beneficiary on one of your assets, your IRA or your life insurance that passes by beneficiary designation. And if your spouse predeceases you, whoever's listed on the contingent beneficiary is now going to get that money.
Right. So it could potentially disqualify that individual from any benefits that they're already getting. So even if they have a supplemental needs trust that's set up, that doesn't necessarily mean that the asset that you leave to the individual is going to end up there. You have to be careful about making sure that you actually name the trust as the beneficiary. So you can also name multiple different trusts as beneficiaries if you wanted to, depending on who was receiving the asset. Sometimes I work with families who set up their revocable trust, right, to sort of catch all of their assets and retitle their assets. They also have a supplemental needs trust for one child. And so they'll name the, contingent beneficiaries to be half of their revocable trust and half to the supplemental needs trust, so that it ends up in the right place for that child.
Right. And you bring up a very good point with that, because that goes right to the heart of it, right? That whole, so you could create all of these, and forgive me, my visual is always buckets, but it's what I use. And some people like bags, some people like pools, I use buckets. So you can create all of these buckets, these different trusts, these different, things. But if you don't change the beneficiary, they're never going to go there, because it's going to get directed by whoever is on the piece of paper at, whether it's the old employer, the IRA, the custodian is going to drive it based on that.
Yeah, you just have to do it, right? I tell all my clients, I kind of give them the options too of when we're going through all these things together, and they understand what needs to be done. And I say, if you're great with paperwork and you want to do this and tackle this project yourself, the retitling and the updating of beneficiaries, that's great. I will give you everything that you need to do that, instructions, template letters, show you how to write out the name of your trust. No matter what they want, I'll give it to them. But the important thing is that it gets done, because intending it for it to happen is not the same thing as actually getting it on paper and submitting it to the right place. So I give them the option too, if they have an inkling that they might not get to all of this paperwork, to just have someone step in, whether it's their financial advisor, their attorney. Sometimes working together can make sure that all of this is getting done properly. And that's really where it's important, like Tom, you said right at the beginning, to really consult with people who know what they're talking about, because even if you go through the exercise but just do one thing wrong, it can really screw up the whole thing.
Right. No, and we do that, it's a big part of, as part of when we do this and talk about it, we talk about it from that, again, I'm in a Jersey, so, we talk from the team aspect and the team format there in terms of going through it, because we really believe that's the case. and I know somebody just jumped into the chat box because I could finally see it. But and Craig would be yelling at me because we're going a little bit over time here with this. So I'm going to start to wrap it up, but I will check on the chat here in terms of going through that to see if there was a question. So it's regarding real estate. Are there any advantages to having a separate real estate trust for one or more properties?
So real estate trusts and nominee trusts, they're really for titling purposes is why they're there. So really the trustees are acting at the behest of the beneficiaries for those types of trusts. They are good because they help to avoid probate. So there's different techniques that we can use for that. Sometimes clients put the real estate directly into their revocable trust. They have multiple revocable trusts. Sometimes it's a good idea to use a realty trust to sort of split the interest between the two revocable trusts. So it's really, so I think the heart of the matter is, using trust to avoid probate, especially with real estate, is a good idea, because otherwise, having to sell real estate and sort of waiting for the probate process to happen is it's tricky to do that. It takes a long time. So having an asset in the name of a trust rather than in an estate allows a successor trustee, to step in and do whatever needs to be done pretty quickly thereafter. There's a few other considerations tax-wise and all that with respect to real estate, but it really depends on the overall plan.
Right. I certainly appreciate that. So this is Craig and I, and hey, how we tie the jerseys in. We like to have fun. This is us in a more fun part of what we do. And if you've ever seen us at any of the conferences or any events, we're generally in the jerseys because we sort of tie that all together. If you go to the website, you'll get a little bit more detail on that. What we do is planning, and we try to help families out. So if you ever know anybody who's got questions or concerns, we're happy to try to sit down with them. We don't charge for it. It's complimentary as far as going through that. That's part of the reason we did Aries the way we did as a nonprofit, so we could continue to do that. We did tell you this was Think with a Drink, so we like to keep that theme going with what's on tap. That's what's coming up. So next week, we're going to do resolution planning. It's that time of the year, right? This is our last one of the year. So the last one we're going to do in 2020, which hopefully will sail us off into the sunset of 2020. But we'll talk about ways, everybody does a resolution, everybody puts them together, and then by February, they're gone. So we'll give you some tips and tricks and ideas of how to stick to a plan, how to put something together. Doesn't matter what you're trying to do. Lose weight, quit smoking, get out of debt, whatever it is, we'll give you some ideas and ways to do that. And then we're off for the holidays, right? So, but we've got some stuff that we're putting together. And so 2021, we're looking forward to come back, some more guests, some more stuff, different topics, and to have a fun time with wonderful Think with a Drink. But just want to reach out there. I know that was a question from the audience. If there's any other questions out there, I will say that if you do have any questions for Amanda, you can go to Amanda. She's at A Mulhall at mulhalloffices.com. You can check her out at mulhallestateplanning.com. Like she said, she's local. She's a Natick. We've referred a lot of clients to her to help, get their questions answered in what I would say is a traditional legalese sense. I got a question coming up.
That was actually me. My email address is mulhalllawoffices.com.
Oh, did I mess it up? Thank you.
Okay, there's a lot of L's all at once.
Yeah, I know. That's probably what happened. Is I probably did it and it didn't fit in the little box and I squeezed it. So thank you. It's actually A Mulhall at mulhalllawoffice.com. Thank you, Amanda, for pointing that out. I certainly appreciate it. If there aren't any other questions out there, I'm going to say, Amanda, again, thank you very much for joining us. This was terrific. I certainly appreciate you spending the time, giving us the input and going through it. I know it's something that, like I said, comes up for us a lot in conversations with individuals, with families. They've always got questions and concerns. And a lot of times it's, hey, look, this is the way you should be thinking about doing something. So we certainly appreciate that. For everybody on the call, want to wish you, in case you don't join us next week, a very safe, very healthy, and happy holidays. And I'm going to stop my share and say, good evening. And by the way, the Pats play at 8:25. Go Pats.
Thank you.